Hello and welcome to Daily News Capsule. Let's try to discuss the important pieces of news that have appeared in the newspaper of the day. So the first news that is coming your way is the signing of Artemis Accord by India. Now on June 21st, India became the 27th signatory to the Artemis Accord, which are a set of non-binding guidelines that underpin the Artemis program, which is a US-led project to return human beings to the moon permanently. Now, the Artemis program includes plans for a base on the lunar surface, multiple spacecrafts to ferry humans and cargo, an orbiting space station, and a constellation of satellites to help with navigation and communication. The first Artemis crew mission to moon surface is likely in 2026. The program resembles Chinese-Russian plan for an international lunar research station. So India became the 27th signatory signing party to Artemis Accord. What is it? It is a set of non-binding guidelines with respect to Artemis program, which is a US-led project to put human beings on the moon permanently. Now this project, this Artemis program is in competition with, you can say, to the Chinese and Russian joint Chinese and Russian plan to have an international lunar research station. And the first Artemis crewed mission to moon's surface, to the lunar surface, will happen in the year 2026. Now, the Artemis Accord supports an American-friendly interpretation of space laws, and in return, the member states get to participate in the Artemis program, which can bring prestige and technological benefits. Now, what are the set of space laws which would be coming into picture, and what are the space treaties and agreements, and how the interpretation of these have changed with respect to India? Now, modern space law is erected on 4 international agreements that cover issues like the peaceful use of space, registration, and liability. These laws were made between 1967 and 1976. This was the time when space race was going on between America and USSR during the Cold War era. Now, the Artemis Accords principles are consonant with these agreements. Artemis Accords, one of the provision in the Artemis Accords allow actors to extract and utilize space resources. This could be going against the Moon Agreement, and the Moon Agreement had been introduced in the year 1979. India had signed it, but it did not ratify, whereas USA and USSR, the Soviet Union at that point of time, had not signed it at all. Now, one of the provisions of Artemis Accord allows actors to extract and utilize space resources. Now, this could be going against the Moon Agreement, as it has been stated earlier, which asks for the gain of commercial exploitation of the lunar resources to be distributed. This has not stopped countries like Australia and France, which had previously signed the Moon Agreement, from becoming Artemis signatories. In reality, the provisions of Artemis Accord and the Moon Agreement are vague enough. They are very much vague, so that the advocates and the lawyers, they can manipulate and play with the language. Coming to India, now what would be the impact? What would be its impact on Indian system? Now, first and foremost, it should be noted that India signing an accord of the name Artemis Accord, this shows a shift between in the thinking of Indian government, where previously the Indian diplomats were used to think that accords were non-binding instruments. They were rather norms, informal norms, and they were not having any binding nature. But what has happened, that India has now made a shift, you can say, and India which has previously or historically preferred legally binding instruments, because it had believed that laws foster better compliance. Now it has accepted the idea of informal norm as well, and has signed a accord. That India has now accepted a set of US-led norms suggest a change in its thinking. Now, what is required of India? What is required of Indian space program? The first thing that is required of Indian space program is a hike, an increase in the budget of ISRO. Already ISRO is executing many of its projects like Chandrayaan and others, Gaganyaan, etc. So the government has to hike the budget, has to increase the budget, annual budget of the organization as well. Now, India must overcome domestic resistance to collaboration with other space agencies, enable its private sector to work with other Artemis members, and to develop legislation that encourages space activities. So this was the information related to Artemis program. Coming to the next piece of information, that is related to a Chinese law, a new Chinese law on foreign relations. Now, on June 28th, China's National People's Congress has adopted a new law on foreign relations of People's Republic of China, which came into effect on 1st of July. Now, this law, as many experts are saying, that this law will tighten the control of the Chinese president over the foreign policy of China. Now, the law involves foreign affairs, and the very first article of the new law says that it is drafted to safeguard Chinese sovereignty and national security and developmental interests. It should be noted that Chinese Parliament had adopted a law related to border management as well, with respect to its borders. Now, this was done in October 2021 when a new border law was adopted that warned against any act that undermines territorial sovereignty and land boundaries of the Chinese state, the country China. Now, what would be the impact of this law on foreign policy? Now, first and foremost, there would be a centralization of Chinese foreign policy in the hands of the president of the Communist Republic of China, the People's Republic of China. Now, the law specifically mentions several initiatives which have been championed by the President of China, such as Belt and Road Initiative, Global Development Initiative, and the Global Security Initiative. Now, the law also emphasizes sovereignty and security as being the heart of Chinese foreign policy. Now, it should be noted that this has led to a change. Why it has led to a change? Because for the first time after many years, state security has taken the front seat, and the developmental aspect has been somehow or to some extent discounted. For example, the new law says that China has the right to take, as called for, measures to counter or take restrictive measures against acts that endanger its sovereignty and national security and developmental interests in violation of international law or fundamental norms governing international relations. It also says that the state shall take measures as necessary in accordance with the law to protect the safety, security, and the legitimate rights and interests of Chinese citizens and organizations overseas, and safeguards China's overseas interest against any threat or infringement. Now, the official reaction coming from the Chinese side said that the objective was a legal response. One of the objective was the legal response to Western sanctions that are always aimed at China. Now, what will happen to these sanctions? The law will reinforce the law on countering sanctions, meaning thereby it is a counter to the sanctions that would be placed on the Chinese authorities, Chinese government, so on and so forth. Now, it should be noted that another section that would be very much important in this regard is with respect to debt crisis. Now, as the point says, that another section of law that appears to be a response to criticism of China's foreign lending. China's foreign lending has always been under scrutiny. Sri Lankan economic crisis is a classic example in this regard. So, a particular section has been added, a particular provision has been added in the new law. Then the provision is Article 19 of the new law, which says that while providing financial aid to any country, China would respect the sovereignty of the recipient country and not interfere in their internal affairs or attach any political conditions to its aid. meaning thereby there would be no strings attached with respect to the aid, with respect to the help, be it financial aid provided to the recipient country by the Chinese side. Now, what would be the implications of such a law on India? Please note that already India is having a border dispute with China, and China has adopted a border law in October of 2021. Now, this border law emphasizes security, sovereignty, and territorial integrity as key features of Chinese foreign policy, which coincide with the border disputes returning to the center of India-China relations. Now, the experts in India say that border law as essentially looking to formalize China's moves along the line of actual control. Now, how will this lead to? What will it lead up to? Please understand that henceforth all the negotiations between the various countries over land boundary agreement or land disputes, China will take a firm position that it cannot go against its own domestic legislation, meaning thereby they would be the one who would be framing the issues when it comes to land boundary negotiations. Uh, Furthermore, Article 6 of the new law says that the state institutions, armed forces, political parties, people's organizations, enterprises, public institutions, other social organizations, and citizens have the responsibility and obligation to safeguard Chinese sovereignty, national security, dignity, honor, and interests in the course of international exchange and cooperation, meaning thereby the new law places responsibility on each and every actor, each and every institution, each and every enterprise to work for, or you can say uphold, sovereignty, national honor, and dignity of the country. Likewise, Article 31 says that implications and applications of treaties and agreements shall not undermine the sovereignty of the state, national security, and public interest, meaning thereby any treaty or agreement should not be going against the idea of sovereignty of the state, national security, and public interest. Likewise, Article 17 and many other articles in the new law have placed the sovereignty of the Chinese state, their territorial integrity, above all else at a higher pedestal in comparison to the other issues like the issues of development. Now, when it comes to companies, when it comes to corporations which are working within the Chinese land, Article 8 of the new law would be would be focused upon, because Article 8 declares that any organization or individual who commits acts that are detrimental to China's national interest in violation of this law and other applicable laws in the course of engaging in international exchange shall be held accountable by law, meaning thereby any company which is violating this particular foreign policy law, or for that matter any domestic law of China, any law of the land of China, would be held accountable in the courts of law as per the Chinese law. Furthermore, Article 33 says that the government has the right to take countermeasures, to take restrictive measures against acts that endanger its sovereignty and national security and development interest in violation of international law or fundamental norms governing international relations, meaning thereby again Article 33 reiterates the very basic idea that for China, as per this new foreign policy law, national interest, sovereignty, and territorial integrity are supreme, and Article 33 gives the powers to the Chinese government to take corrective measures, to take countermeasures against any act which is trying to undermine these ideas, these things. So this is the news related to China's foreign policy law. You can find this in the newspaper as well. Coming to the last news, that is, this is related to the health and welfare sector. The news is related to the pharma industry, and as you all know that some of our pharmaceutical companies have been under scanner because of the quality of drugs that they are making. Now, this is related to the cough syrup and other medicines that have been exported to different countries in Africa, and some children died over there, and that is why this entire sector, this entire industry came under scrutiny. Now, this article tries to analyze that what are the various causes, or you can say what are the various reasons for such kind of a behavior, and what has been the response of various countries after the deaths that have been reported in their respective countries. Now, since last October, Indian pharma companies have been under constant international security because red flags have been raised over the consumption of certain drugs. For example, Cameroon has sounded an alarm. Sri Lanka has said that 2 drugs manufactured in India are having adverse reactions. Gambia has declared that from July it will be running strict quality control checks. July 2023, it will be running strict quality control checks on all pharma products that would be coming out of India. Likewise, Mozambique has also said that it would be like Mozambique has said that it would be checking samples. It has been checking samples to be very precise, which are coming out of India, which are being exported out of India. And when these reports came that deaths have occurred, Indian pharma companies like Marion Biotech, the licenses of these companies have been cancelled by the Central Drug Standard Control Organization, which is under the Ministry of Health and Family Welfare. Now comes the question that what are the reasons, and has some reasons been provided by the government? Has an investigation come into picture or not? Now, the article says that the Ministry of Health and Family Welfare has not answered any question on the probe that was launched, meaning thereby what was the result of the probe, it has not come to light. Now, the thing is that ideally speaking, when a manufacturer is found to be violating laws, then there is which creates a threat on life, a criminal prosecution is launched. Now, under Drug and Cosmetics Act 1940, manufacturers not adhering to good manufacturing practices can be subjected to a maximum punishment of imprisonment for life. Now, this is the provision, but then the problem is that if the prosecution is filed, even if the prosecution is filed, then the court case runs on a very slow pace, meaning that the speed of the case is very slow. This gives an impression that nothing is happening to these pharma companies who had done some wrongdoing. On the top of it, the article highlights the fact that there is an unscientific division of work when it comes to importing and approving a drug, and giving licenses and prosecution and launching a prosecution in case of some wrongdoing. Now, the point says that under India's convoluted drug regulatory laws, the center is responsible for imports and approving the new drug based on the safety and efficacy data, but the licensing and prosecution of the pharma companies is the responsibility of the state government. So this unscientific division of work has also led to problems with respect to this regulatory mechanism within the pharma industry. Now, another point that is highlighted in the article is that poor conviction rate has always been there with respect to these pharma company cases. And why? Because the errors, the procedural lapses that have been committed by the drug inspectors, which include bad paperwork, shoddy paperwork, failure to seize, record the condition of the medicines and the other drugs, storage and labeling of the samples, and the failure to complete, most importantly, the failure to complete the testing process within the limited time frame, because all the medicines would be having an expiry date. So if the testing has to be done, it has to happen before the expiry date. So all these factors lead to a bad name, a bad reputation for Indian pharma industry. So this was all the news that were important, that were newsworthy in today's newspaper. I'll meet you in the next session. Thank you very much.